All right, good morning. My name is John Bolger. I'd like to call this meeting to order. First order of business that I have is to welcome Mr. Roger Nick. Roger Nick is Speaker of the House, Sam Smith's appointment. And Roger, on behalf of all the commissioners, we welcome you to the Pennsylvania State Ethics Commission.
Honored to be here.
Thank you. Thank you. Okay, let's go to our agendas. First item is the approval of the September 24th public meeting minutes. I'd like a motion to adopt those, please.
So moved.
Motion by Commissioner Polk, second by Commissioner Caldwell. Any questions, comments? All those in favor say aye.
Aye.
Any opposed? Minutes have been approved. Okay. I will read to you an announcement. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting was held on September 24, 2012. And executive teleconference meetings were held on October 19, 2012 and December 21st, 2012 to review matters that are by statute 65 PACS 708-1108 confidential, including to receive legal advice and discuss litigation and/or complaints in connection with assertions made by Matthew Haverstick, Esquire, on behalf of the Senate Republican Caucus. The review and consideration of applications for 90-day extensions of investigations filed by the Investigative Division. The review of completed investigations for the purpose of issuing final adjudications. The consideration of the assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries. Also to review pending litigation and to discuss the process for filing the position of Commission Executive Director. An executive committee meeting will be held today, January 28th, immediately following the public meeting to review matters that are by statute 65 PACS 708-1108 confidential, including to receive legal advice and discuss a letter received from Senate President Pro Tem Joe Scarnavi involving pending litigation. To review and consideration of applications for 90-day extensions of investigations filed by the Investigative Division. The review of completed investigations for purposes of issuing final adjudication. The consideration of assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries and the review of pending legislation. So, back to the agenda. First item on the agenda is the Troy opinion. Commissioner Nick, the way we handle this is individual commissioners are assigned cases, and this one is assigned to Commissioner Bergen. And Ms. Bergen, would you please proceed?
Yes. The facts, excuse me, the facts pertaining to this advisory request are brief. The requester is Dennis H. Troy. Mr. Troy is a registered lobbyist in Pennsylvania. The question presented for an advisory opinion is whether, pursuant to lobbying disclosure law, Mr. Troy would be permitted to run in the 2013 primary election for the office of Mayor of Brentwood Borough, located in Allegheny County, Pennsylvania. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on the matter.
Mr. Troy here, or any of his representatives? If not, please proceed.
Mr. Chair, I have reviewed the facts and relevant statutory provisions. Section 13A07 of the lobbying disclosure law prohibits certain activities. The prohibited activities listed in section 13A07 of the lobbying disclosure law involve service by a lobbyist as an officer of a candidate's political committee or a candidate's political action committee where the candidate is seeking a statewide office or the office of state legislature. Fee restrictions where all or a portion of a lobbyist fee would be converted into a contribution to a candidate or political committee subject to reporting under the Pennsylvania Election Code. Falsification in the course of lobbying. Conflicts of interest in the course of lobbying. Contingent compensation arrangements. And 10 categories of unlawful acts. The lobbying disclosure law does not contain any prohibition against a lobbyist seeking or holding municipal office. Given my analysis, I would like to make the following motion. I move that the holding of the commission in this matter be as follows. As a registered lobbyist in Pennsylvania, Mr. Troy is subject to the prohibitions, restrictions, and requirements imposed upon lobbyists by Pennsylvania's lobbying disclosure law. The lobbying disclosure law would not prohibit Mr. Troy from running in the 2013 primary election for the office of borough mayor. So moved.
Is there a second?
Second.
Okay, you've heard the motion, and any comments, questions? The lobbyist wants to become a mayor. All those in favor, please signify by saying aye.
Aye.
Any opposed? Mr. Troy will receive the information.
Excuse me, Mr. Chair, would it be appropriate to note the postponement of
I'm
the
sorry
Act?
to hear you.
Would it be appropriate to note the postponement of the Act 29 guideline matter in case anyone in the audience is waiting for that? I don't know if anyone is, but these are the guidelines that the
Yeah,
legislative...
right, okay, yeah, I'd be happy to. Okay, for the commissioners, that's item number 6 on the agenda. If you recall, at the last meeting, the gentleman spoke to us about the Valley Forge Military Academy, the scholarships, and this commission was under the direction to provide guidelines for the offering of these scholarships. They were prepared and sent to the interested parties, including all 4 caucuses of the General Assembly. We have received a letter from the 4 caucuses that requested that we postpone any action today until we have received their input. It's a legitimate request. They didn't have a lot of time to look at it, and so what we can do is postpone it today. If you're in agreement, they will send over their comments as well as the gentleman from the Valley Forge Military Academy, and then we will take action probably in a subsequent conference call. Does anyone have any questions on that? If not, I would entertain a motion that we postpone until the next meeting, whether it be conference call or public meeting, to take action on these guidelines for the Valley Forge Military Academy scholarships to be offered by members of the General Assembly.
So moved.
Moved by Commissioner Porter,
Second.
second. Okay, any questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Okay, that takes care of 6. Anyone in the audience who's interested in that, we took that out of order. Okay, let's proceed back to our agenda. Item number 3, civil penalties, orders. Commissioner Corrigan was assigned to these consent agreements, and please take it from there, Commissioner Corrigan.
There are 8 administrative penalty cases with proposed consent agreements for our consideration. The following 8 respondents are principals that failed to timely file a quarterly expense report for the first quarter of 2012 in their capacities as registered principals. They are BLN Partners, National Character Education Foundation, Multipurpose Stadium Authority of Lackawanna County, CMS Companies, the Technology Council of Central Pennsylvania, National Wrestling Coaches Association Incorporated, Conterra Ultra Broadband LLC, and Hindman Area Health Center. In each case, the parties are in agreement that the respondents' transgressions of the lobbying disclosure law were negligent. The respondents have already filed their delinquent expense reports and they are in the process of paying the agreed upon penalties. The Technology Council of Central Pennsylvania has agreed to file a notice of termination of its principal registration with the Department of State and has also agreed to a 3-year prohibition on lobbying, subject to any applicable exemptions set forth in Section 13A06 of the Lobbying Disclosure Law. Hindman Area Health Center has agreed to file a notice of termination of its principal registration with the Department of State. It has also agreed to refrain from any and all lobbying activities in Pennsylvania for 3 years from the date of issuance of the Commission's order. The parties are free to contract to such terms in a consent agreement. Based upon my review of these facts, I am of the opinion that the consent agreements are proper dispositions for the respective cases. Before I would make a motion, though, I would like to ask a couple questions or get some answers for the record while we're here. I note that the penalty period for changes for some of these individuals, for some it runs from May 1st, and from other individuals it runs from the end of the warning period, which is quite a substantial time later on the number of days, the penalties that are assessed. And some folks are assessed a penalty of from $30 to $35 to $50 a day in these various consent decrees. Could someone address that, please?
Basically, they're negotiated settlements. And when our legal staff will meet with representatives of the various lobbyists, it's a give and take process where we could go up to $50 a day with a penalty that, depending on, if they're cooperative with us, we then will reach an agreement based on the number of days, and also it's a sliding scale amount that we come up with. So it's not anything hard, no hard and fast rule that it's going to be $50 a day. We've had negotiations probably from the time that we start initiating this process.
Okay. One other question. These penalties are being assessed for failure to file for the first quarter of 2012.
Correct.
Ended March 3rd, at the end of March. The letters that went out advising them that they were in non-compliance did not go out until July 10th. That's another quarter later.
Yes.
It seems awfully late to me.
It is. It is late. It's what we have to rely on when we start to initiate this penalty process is information that's given to us by the Department of State of all of the principals and lobbyists who are filing. It takes them sometimes 3 to 6 months after the quarter is over to give our staff the information that we need and then to proceed to identify all of the non-filers. So their process is backed up, and in turn that backs us up. We've tried to work with their staff. It's gotten a little bit better, but not a whole lot better in the last, in over 2 years. They're shorthanded and we're shorthanded.
It would seem to me that I could understand that if people were flipping through each one of these things by hand, looking at paper, but it would seem to me you could push a few buttons on a computer, a few days after the end of the quarter, and what would pop out are the folks that didn't file their...
In theory, that's correct, but there are some that still file paper documents, and then those paper documents come in late, and then they also have some people that will file both paper and electronically, and their systems, they then have to cross-check what they have filed online as well as what their paper filings are. And if that's what is their time lag, I don't know.
We're just stuck with whatever they do.
We're stuck with whatever they give us.
All right. Anyone have any other questions? Then I do move that this commission approve the consent agreements submitted by each of the following respondents in the Investigative Division and impose the following administrative penalties for the respondent's delinquent expense reports for the first quarter of 2012. As to VLN Partners, CMS Companies, and Conterra Ultra Broadband LLC, 1 administrative penalty per respondent in the amount of $3,600 each. As to the National Character Education Foundation, the Technology Council of Central Pennsylvania, and Hinman Area Health Center, 1 administrative penalty per respondent in the amount of $950 each. As to Multipurpose Stadium Authority of Lackawanna County and National Wrestling Coaches Association Incorporated, 1 administrative penalty per respondent in the amount of $4,200 each. I further move that the Technology Council of Central Pennsylvania be ordered to file a notice of termination of its principal registration with the Department of State within 30 days of the issuance of the Commission's order, and to fulfill its agreement to a 3-year prohibition on lobbying, subject to any applicable exemptions set forth in Section 13A06 of the Lobbying Disclosure Law for a period of 3 years from the mailing date of the Commission's order. And Hinman Area Health Center to be ordered to file a notice of termination of its principal registration with the Department of State within 30 days of the issuance of the Commission's order, and to refrain from any and all lobbying activities in Pennsylvania for 3 years from the date of the issuance of the Commission's order, as the parties have agreed.
Okay, you've heard the motion. Is there a second? Second, Commissioner Colafello. Any other questions or comments of legal counsel or Mr. Caruso? These are consent agreements, so they agreed. So, okay. All those in favor, please signify by saying aye.
Aye.
Any opposed? Proceed. Thank you, Commissioner Corrigan. Next item on our agenda, item number 4, the Morton Advice of Counsel, Commissioner Wolf.
Thank you, Mr. Chairman. The facts pertaining to this appeal of advice are as follows. The appellant is Michelle D. Morton. Ms. Morton has appealed Advice of Counsel 12-568, which was issued for her on October 15, 2012. At the time that Ms. Morton submitted her initial advisory request, she was employed by the Commonwealth of Pennsylvania as an adult personal care homes licensing representative with the Pennsylvania Department of Public Welfare, which I shall refer to as DPW. Ms. Morton was going to terminate her Commonwealth employment on September 7, 2012, and she sought guidance as to whether the Ethics Act would impose any restrictions upon her in her new position with a new employer. Advice of Counsel 12-568 determined that as an adult personal care homes licensing representative with DPW, Ms. Morton would be considered a public employee subject to the Ethics Act and the regulations of this commission. The advice determined that upon termination of her employment with the Commonwealth, Ms. Morton would become a former public employee, subject to Section 1103G of the Ethics Act. The advice set forth the restrictions of Section 1103G of the Ethics Act as applicable to Ms. Morton and her performance of job duties for her new employer. By fax letter received on November 16, 2012, Ms. Morton appealed Advice of Counsel 12-568. Ms. Morton's appeal letter was undated and was accompanied by a fax cover sheet dated November 15, 2012. Ms. Morton's appeal letter did not state any particular basis for the appeal. The threshold issue we must decide is whether Ms. Morton filed a timely appeal of Advice of Counsel 12-568. Mr. Chair, I'd suggest that this would be an appropriate time for any interested parties to speak on this matter.
Is Ms. Morton here? Anyone representing Ms. Morton? If not, please proceed.
Mr. Chair, I have reviewed the facts and the relevant statutory provisions. I would note that pursuant to sections 11.1 and 13.2 subparagraph H of the regulations of this commission, and sections 31.11 and 31.13 subparagraph A of the general rules of administrative practice and procedure, any appeal of an advice must be in writing and must be filed with, that is, received by, this commission within 30 days of the issuance date, which is the mailing date of the advice. I would further note that Pennsylvania courts have held that the timeliness of an appeal filed with an administrative agency is a jurisdictional issue, and that the time for taking an appeal to an administrative agency board cannot be extended as a matter of grace or mere indulgence. The appellant carries the burden to justify an untimely appeal. In the instant matter, Advice of Counsel 12-568 was issued on October 15, 2012. Any appeal of the advice had to be filed with this commission within 30 days of October 15, 2012, that is, by November 14, 2012. However, Ms. Morton's appeal of the advice was filed by fax transmission on November 16, 2012, 2 days beyond the appeal deadline. Ms. Morton has failed to establish any circumstance to justify her untimely appeal. It is my view that Ms. Morton's appeal is untimely and must be dismissed. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. The appeal of Advice of Counsel 12-568 is dismissed as untimely filed.
Thank you, Commissioner Volk. Is there a second?
Second.
Second, Ms. Burden. Any questions or comments? If not, all those indicate, please say aye.
Aye.
Any opposed? Motion approved. Thank you, Commissioner Volk. Next item on the agenda, item number 5, is gaming. Mr. Nick, commissions involved the Gaming Commission, the lobbyist registration law, and the ethics law. So this one involves gaming, and that was assigned to Commissioner Colfello.
Thank you, Mr. Chairman. Facts pertaining to this request is as follows. The requester is Stephen Campolongo. Mr. Campolongo has requested a determination of the commission pursuant to section 1512 8.5 of the Pennsylvania Racehorse Development and Gaming Act, which I shall refer as the Gaming Act. Mr. Campolongo has applied for a gaming level 2 employee permit for a count room lead position at Valley Forge Casino. In connection with his application, Mr. Campolongo disclosed to the Pennsylvania Gaming Control Board that he had been appointed to the position of Judge of Election for the 2012 election. In his request letter, Mr. Campolongo additionally notes that he has served as Minority Inspector of the Election, but it is not clear from the submitted facts when that service occurred. Mr. Campolongo states that his appointment as Judge of Election for the 2012 election occurred at the last minute due to the sudden retirement of the previous Judge of Election. He states that he will be not serving as Judge of Election in the future and that he has never served as a committee person. At the request of the Gaming Control Board Office of Enforcement Counsel, Mr. Campolongo seeks a determination from the Commission as to whether service as an appointed Judge of Election or as Minority Inspection of Election in the 1st Ward, 4th Division in Philadelphia would bring him within the definition of the term public official as set forth in section 1512 of the Gaming Act, and would therefore cause him to be subject to the restrictions of section 1512A, 1 and 2 of the Gaming Act. Mr. Chairman, I would suggest that this would be an appropriate time for any interesting parties to speak on this matter.
Is there anyone here, Mr. Capanal, or any of his representatives? Seeing none, Mr. Caldwell, please proceed.
Mr. Chair, I have reviewed the facts and relevant statutory provisions. It is my view that none of the 5 numbered paragraphs in the Gaming Act's definition of the term public official would apply to Mr. Campolongo. Paragraphs 1 and 2 obviously would not apply to him. Paragraph 3 would not apply to Mr. Campolongo because the positions of Judge of Election and Inspector of Election are not counted in municipal offices. Based upon the submitted facts, paragraph 4 would not apply to Mr. Campolongo because there is no indication in the submitted facts that the election board of the 1st Ward, 4th Division in Philadelphia has directly received a distribution of revenue under the Gaming Act. Paragraph 5 will not apply to Mr. Capilongo because the positions of judge of election and inspector of election would have no involvement in developing regulations or policies related to licensed entities under the Gaming Act or other matters related to the Gaming Act. Given my analysis and comments on this matter, Mr. Chairman, I would like to make the following motion that we accept my recommendation.
Did you make the motion?
Yes, I did.
Okay, I'm sorry. You heard the motion, is there a second? Second. Commissioner Corrigan? Okay, any questions or comments, Commissioner Caldwell? If not, all those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Okay, moving right along, item 6 on the agenda, we took out of order and we took care of that. Item 7 is payment schedule. We call from time to time, God bless you, we set up payment schedules based on fines levied by this commission. Mr. Caruso, do we have any payment schedules? Sometimes we allow them to pay so much a month or so much, and maybe you ought to explain it. You can do that better than me.
Yeah, as a result of some rulings that are issued by the commission due to the amount of the penalty, we enter into agreements with respondents that they can make monthly, quarterly payments over a certain period of time. That has worked pretty well for the commission as well as for the individuals subject to the adjudications. For this past, since the last commission meeting, there have been no payment schedules to report for this time.
Okay. Any questions for Mr. Caruso? Payment schedule? Okay, that takes care of item 7. Okay, according to legal counsel, if you recall in our conference call, we appointed Mr. Caruso as acting director upon the resignation of Executive Director John Contino, and we will need to ratify this appointment of Mr. Caruso as acting director effective January 12th. That way it'll be reflected in the minutes of this public meeting, and I would request a motion that you approve the ratification on an action that we already took.
So moved.
Second.
Moved and second. Any questions or comments? It's just a formality. Okay. All those in favor, please say aye.
Aye.
Any opposed? Okay. That brings us to the special election for vice chairman. And I'm going to read some information that you need prior to this election, which we just had one at the last meeting. So it's due to a vacancy, a special election is needed to elect a vice chair of this commission. Pursuant to Commission Resolution 85-002, notice of a special election must be publicly announced at least 30 days prior to such election and forwarded to all members of the commission. Given that there were fewer than 30 days between January 2nd, 2012, when the vacancy occurred, and the public meeting scheduled for today, it was not possible to provide 30 days notice of a special election for today's meeting. On January 3rd, 2012, the public and members of the commission were notified of the special election that is scheduled for today. In order for a special election to proceed today, and so that the commission will be able to conduct its business with a full complement of officers, I would ask for a motion to waive and/or suspend the requirements of the 30-day notice of a special election that is scheduled today. Well, first of all, do you understand that? And then I would request a motion so that we can proceed with the special election and suspend the 30-day requirement. That's all that's it.
I'll make the motion that we suspend the 30-day requirement.
Okay, Commissioner Bolt, is there a second?
Second.
Commissioner Bergen, second. All right, any questions or comments? Thank you very much. Okay, all those in favor, please say aye.
Aye.
Any opposed? We will have the election, which is the next item of the agenda. At this time, I would call for any nominations for the vice chairman of this commission.
Mr. Chair, I would like to nominate Nick Colabello.
Commissioner Bergen nominates Commissioner Colabello.
I'll
Any other
second that. I'll
nominations?
second that nomination.
Second. Okay. Any questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Nick, we will look forward to working with you. And I hope your term lasts longer than Don McCurdy. Okay, thank you. I probably should have said that. Okay, that concludes our public meeting today. Thank you for those that attended. Maybe let's take a 5-minute break, please.